we do the case law thing, and one thing I would tell everybody about AI, do not use AI and just run with it.
Yep, exactly. No, you're going to waste your time.
Yeah.
I mean, they write some pretty good language that sounds good, but then you go to the case site and it's like it doesn't even exist. It's called the phantom case site.
Right.
Um,
And maybe if he comes on daily, we'll explain how that works, because I didn't get that at all. But we know we shepherdize here. I think you all on your screen should be seeing the check that they gave me in the release, as Brett finds that. But clearly, this release contains just facially, the release contains more language than the stipulation.
all right, I found it, Greg.
All right, go ahead.
All right, so I'm going to read you a quote here from case law. By analogy, a frivolous pleading is one that on its face is so readily recognizable as devoid of merit that there is little, if any, prospect whatsoever that it can ever succeed. And it provides case law, Yasir v. Hancock.
I
That's
believe that's Florida, right?
Yeah, that's Florida, second DCA.
If you can put that inside the chat room for people. But also, it said there's a statement about merit, correct?
Merit, let's see.
Or fact. He says he has to have no basis in fact or in law for it to
Right,
be frivolous.
right. And then there's the third district chimed in here and says, we recognize to some extent that the definition of frivolous is incapable of precise determination. Nevertheless, a review of the Florida case law reveals that there are established guidelines for determining when an action is frivolous. These include where a case is found to be completely without merit in law and cannot be supported by a reasonable argument for extension, modification, or reversal of existing law. That's A. B, to be contradicted by overwhelming evidence. C, as having been undertaken primarily due to delay or prolong the resolution of the litigation, or to harass or maliciously injure another. Or D, as asserting material factual statements that are false.
There you go. Stop. Material,
Yep.
factual statement. Material.
Yep.
Something's material when it can affect the outcome. People, just as a little bit of background and so for understanding. So what we're looking at on the one that I filed, we saw the language about voluntary, which if there are arguments I did it voluntarily, the order wouldn't exist. Also, what I learned in another case of mine is whenever you settle an action, and I'll look this up on the background and show you all something. Whenever you settle an action as a litigant, the prevailing party under Florida law has to do what's called a disposition form. And essentially saying, okay, I have agreed to this particular settlement. What does not exist in case 2018 CA 3553 is me executing a disposition. When it came back before Judge Peacock, and her release, by the way, includes parties to include the nation's largest insurer. And look at all this that they wanted me to release. And this is their anything. And here's the word, any kind whatsoever litigation for something that has nothing to do with Shonda and Linda Tucker. The other part that's pretty important, and if there's any attorney listening, I'd love to have you all chime in. Michael Rowe never filed a notice of appearance on behalf of these other individuals like Dr. John Shim, although he did file a protective order for Dr. Shim before stating that he doesn't represent him. Shim Spine, its affiliated companies, and all these other people. You'll see the Department of Veterans Affairs, which is, you see this right here, and you see the U.S. Department of Veterans Affairs. That means the United States government.